Hello everyone, once again welcome to the YouTube channel of Get Set Law by IMS. Continuing with the series of monthly roundups for current legal affairs, which is already there on our YouTube channel for the month of May. Now it's time for the month of June. So without wasting much of time, I would want all the students who's watching this video, please be ready with a pen and a copy so that you write down the topics, you take a screenshot and keep it with you. Since this video has a summary of near about 10 cases which happened in the month of June, which may become important from the point of view of CLAT exam, which is in context with the current legal knowledge. So I would want all of you to understand the summary, but please go and read about this particular thing. So you have to go and Google it up and search the article on this particular topic and write to mention that particular keyword, that is June 2025. Okay, so let's start with the session.
To book a free one-on-one law counseling online or at any IMS center, check out the link in the description box or the pinned comment below.
So over here, these are the topics which were there for the month of June. So these are the 10 topics. Individually, we're going to take up all these topics. If it's clearly being visible, I would request all the students to take a screenshot. And if any given point of time, you guys are not able to understand any topic, कुछ समझ नहीं आ रहा है, कुछ doubt है, कुछ clarity चाहिए, please drop into the comments and keep sharing our videos and show the love which you guys have already been doing. Okay, so the first case over here is alimony must match the married lifestyle. Okay, so this was in context with alimony, that is when the couple got separated, there was a maintenance alimony which was said by the court to give it by the husband to the wife. So the wife came into the picture, and then in June 2025 Supreme Court has given an order to increase the maintenance from 20,000 to 50,000 per month. So जो divorced women थी उसका ये compensation, the maintenance has been increased. So court even ordered a 5% hike every 2 years to adjust for the inflation. So ये matter was in context which was already there before the court, which was already decided कि उनको 20,000 per month होना चाहिए. But the wife came up with a petition कि भाई my husband is already earning, ex-husband not the husband, is earning 4 lakh per month. So he is earning better and I am not able to maintain the similar life, and I even have a son for his proper care I need to be taken, so it should be increased from 20,000 to 50,000. So he claimed, but the husband, ex-husband was claiming that the income was 1.64 lakh only and new family responsibilities also. That means he must have been in a relation and starting up his own life over here. Okay, so the final verdict came was the maintenance raised to 50,000 with 5% hike every 2 years, and wife retains the flat, son gets no mandatory support, but inheritance rights was already been there. This was the case that talks about that alimony must match. So this was a verdict which was given by the Supreme Court in their judgment. Okay, so there are few legal concepts, as every time we have been doing that, why this case is important, that is altogether an aspect which is there, but all these terminologies are there because when you come across any of the paragraph in the exam, it should become more relatable. Okay, so the first one, it talks about alimony. What does alimony means? And you must have already went through in the Hindu family law and even the Muslim laws also, where the term alimony and maintenance came. So it's a money one spouse pays it to the other after separation or divorce to help cover basic living expenses. Okay, so continuing with this thing only, I would just want to make one point to all the students. So majorly the students who are not part of IMS Get Set Law, they have access to these 10 cases which happened in the month of June, but who are already part of our esteemed institute, we do conduct a weekly current affair and weekly legal current matters also to the students, which happens across pan India, and this is one of the great feature which IMS Get Set Law is having. So if you have not been part of any of our batch, please go and check out the link which is given in the description, and please talk to our education advisors if you want any support from them. Okay, chalo, coming to the part which says that alimony is there which one spouse give it to the other one when during the separation or divorce happens. What is a permanent alimony? So it's basically considered to be a long-term financial support which is given regularly after a divorce, usually until the receiving spouse remarries. So it is a long-term basis, that is not only for few months but for a year, but it is subject to the condition that receiving the spouse until they remarries one. Okay, then there was also section 125C of the CRPC criminal procedure which was taken, which is a law that allows wives, children and parents who can't support themselves to claim maintenance from someone legally responsible for them. Under this section only, the wife brought up a petition before the Supreme Court, and Supreme Court chose the reason given that thing, okay, we'll allow you from 20,000 to 50,000. Then Section 24 of the Hindu Marriage Act also says, lets a spouse ask for the money which is during a marriage case if they don't have enough income to manage their expenses also. So that is also, again, this particular aspect comes into the Hindu Marriage Act also, that I already stated earlier. Then it says there is also a concept of cruelty, a valid reason for divorce, including the physical and the emotional harm. So one of the grounds becomes a cruelty, and where when they are separated and not able to maintain their life, then in that context they definitely ask for the maintenance. But to maintain the person's lifestyle, in that context you can definitely ask under this particular section, because you need a proper maintenance, because earlier when you were together you were able to lead a very good financially free life, and you have even been asked to leave the job. So majorly it happens for the females, because they leave their home and then they come and start staying with a man, and then she's been asked to take care of the household things and everything, and maybe asked to leave a job or maybe having a baby. Then in that duration, anytime she has to give up her job, maybe for a year or for two, it totally depends upon the couple also. But during that time, now she has been left undone without having any job. Now she needs some financial freedom, her own life to maintain, and then when she's asking maintenance, that is a valid point which has been given under these particular sections. Now the second one talk about is a bail got cancelled in a post-poll violence case. That means already there was a polling which has happened, and a particular person has done something very brutal, something very wrong against a person who belonged to a party which was in minority in that particular case. Okay, so let's understand what happened. In 25, Supreme Court has cancelled a bail which was granted to accused in a violent West Bengal post-poll attack. That means there was a polling which happened. He must have been won or lose, that's a different aspect. But in that case, when he got the power, he brought up a attack against a person who belonged to the party which was a minority in that the polling part. Okay, there was some election which was going on, okay, in the West Bengal. So victim house was bombed, property looted, wife stripped and assaulted by the mob. So now it was a long crowd which came into their house, and this is what the brutal thing which they have done, which was not correct. So court called it a dastardly offense threatening democracy. So in that, what was the question which came? So when a particular person was given a bail despite serious charges, attempted raid, explosive use and unlawful assembly. So this is something wrong, because he was already taken into the custody and having some political support or maybe some connects, he was granted bail, which was not right. So that's why Supreme Court have cancelled that bail. That's why the title says bail cancelled in a post-poll violence case. So Supreme Court had to decide if bail was justified in politically sensitive and the violent case. So Supreme Court has been given the power, and they will going to give their own judiciary review about whether the bail should be granted or not. Okay. Talking about the final verdict, what happened? So bail got cancelled, accused to surrender in 2 weeks or going to face a judicial custody, and trial to be concluded. So whatever the case have been lodged against that particular person and the entire mob, after that election happened, Supreme Court had given a victim, a witness, a police protection also. Okay, so that is why, because they were already being threatened, a brutal case was already taken place, bombed, they entered into their house and even striped off the wife, and which was not to be done in any aspect. Okay, so that's why this thing was clearly been given by Supreme Court. So there are few legal concepts which comes over here, since we talk about that bail was granted. What exactly bail? So bail is technically considered to be a temporary release of an accused. So just to make it a point, the person was already an accused of an offense, but he might be in a custody till the legal proceedings, the final conviction comes. So he is out on a bail from jail while the trial is still ongoing. That is what it mentions. Now the second concept talks about is the first information report. That is a very basic term which always comes in even the movies also, that something wrong has happened, तूने FIR कराई कि नहीं, that is what it comes. So what is that FIR? It is the first written report which is being filed with the police. Now this is important, it is not going to the court, it's going to the police when a crime has been reported. And then it talks about an unlawful assembly, because the entire mob came into that picture and attacked the entire house. So a group of people, so unlawful assembly means everyone is assembling at a spot where they would have not been allowed. वहाँ पे आपको assemble नहीं होना था, गलत तरीके से, गलत सोच इंटेंट से अगर आप गए थे, that is unlawful assembly. A group of people which have gathered to commit a crime or disturb the peace. So this was in context with this. And the last one is talking about the custody, when a person is held by the police or the court. So it could be the police custody also, it could be judicial custody also. So authorities, which is either before or during a trial, that is the person needs to be in custody because he is threatening people and should not be out on bail. So this is what was the context which was defined. Okay. So now talking about the third case, which is a very interesting case, and I think the students who are still there on social media should have not been there, but I believe that you guys are using social media where you are on the multiple channels, Instagram and pata nahi kya kya jagahon pe, you can Snapchat and everything. So you should cut off that particular thing. It's a big thing because it's a big exam which is going to come in the next 5 months. So get away from social media. So but have been there trending related to a Momo chain, a very renowned brand, that is Wow Momos. So a consumer dispute case was brought before the consumer court where they said कि भाई हमें तो chicken momo supply कर दिए थे instead of we even ordered a veg momo. So what exactly happened is consumers have alleged that they said कि भाई हमारे पास veg momos we have ordered and now they have served us chicken momos, which is impacting our and क्रिएटिंग एन इमोशनल डिस्ट्रेस, और हमारी रिलीजियस सेंटिमेंट्स हर्ट हो रहे हैं क्योंकि हम तो वेजिटेरियन है. ठीक है, आप वेजिटेरियन है, कोर्ट ने कहा ओके, बट अगर आप प्योर वेजिटेरियन है, आपकी कम्युनिटी में नॉनवेज वगैरह कुछ भी अलाउड नहीं है, देन व्हाई यू आर ऑर्डरिंग अ फूड आइटम फ्रॉम अ रेस्टोरेंट वेयर नॉनवेज इज ऑलरेडी सर्व्ड? That is a question which Supreme Court has put forward before them. The consumer court, sorry, not Supreme Court, the consumer court has put forward कि if you are saying that your religious sentiments are going to get hurt, you already knew. Yeah, that is understood कि if you have ordered the veg momos and you have been served as chicken momos, it's wrong and you must have, if eaten, then there is something which is a bigger compensation could be asked. So the majorly why this case raised concern, because the consumer demanded 6 lakh as compensation, irrespective of the fact jahan pe already the company has given them the refund, they have even provided them a voucher, all things done and dusted. Okay, it was a wrong order delivered, it's okay, a lot of time it happens, even on the other delivering app also it happens. So automatically they give you a refund if something wrong happens. Okay, because human beings are only there, it's subject to error, but emotional distress and hurting sentiments was not something which the court could give due regard. So was there a deficiency in the service? Question आता है कि भाई service में deficiency थी. The answer came no. Do emotional religious claims qualify for compensation? And consumers have further argued that the wrong food affected their religious belief. So the final verdict claimed that the complainant dismissed by the court. The complaint was dismissed by the court. No deficiency in service was proven. So whatever service they were offering, उसमें deficiency नहीं थी. The order was taken properly and even the invoice mentioned that it was chicken momos, it was not veg momos. So that's why you could have seen the invoice also. Like whenever we get an order at home, before opening your own parcel, we see what are the items being written, because a lot of time maybe on Sundays or maybe on events like New Year or Christmas where people celebrate, gather, तो उस time पे गलत order जाने के there is a probability. I'm not saying that they are doing something wrong, because when you see that there is someone is claiming that their service was not done, there was a deficiency in service, तो फिर उनका इंटेंट पता चलता है. भाई उनका इंटेंट थोड़ी था कि दे वांटेड यू आर अ वेजिटेरियन एंड वी वांट यू टू ईट चिकन. नो, इट वाज नॉट दैट केस. सो दैट्स व्हाई द डेफिशिएंसी पार्ट डिडंट केम इनटू द पिक्चर. सो क्लेम टर्म्ड बेसलेस एंड हरासमेंट, baseless case and no harassment happened, and no award of 6 lakh compensation should be granted, because a lot of time people come up to the consumer court and ask for it. Okay. Now what are the legal concepts? So there is a Consumer Protection Act which the law clearly provides supports to the consumers who have been given a wrong service or an unfair trade practice have happened with them. It is not context with only food, it is context with all the goods and services which comes, whether offline or online. Then deficiency in service means a fault, imperfection or inadequacy in service performance under the Consumer Protection Act, which has not been there in this context. Next is a religious sentiment claims, emotional or belief based grievances arising due to perceived religious offense must be proven with proper clarity. This needs to be proven. Now you say कि delivering a chicken momos from a restaurant who's serving both type of dishes is hurting your religious sentiments, which is wrong. If you are really a religiously practiced guy or a girl, then in that case you should have went for a pure veg restaurant and ordered that. if something would have happened over there, then there could have been some sentimental problem which could create a case, but totally depends upon how you prove it. Then a goodwill gesture, a voluntary. So this was out of the goodwill gesture, the company Wow Momos have provided them with a proper voucher and a compensation. So a voluntary act by a company to maintain the customer, like a refund, a voucher, and not an admission of the fault. So they don't say that we have created a fault, but since something wrong happened with you, a wrong experience, that's why we are giving you a voucher. And the last one talks about a malified intent. This is what was lagging in the service. If the intent would have been proven, then in that case, so malified intent means a wrong intent which have been brought, a dishonest motive behind filing a legal complaint, which have been used here to imply the complaint was for harassment. If you would have said that it was for harassment, then it could clearly understand that the complaint which was raised was a wrong intent. Next, we move towards an interim bail granted. It's related with a social media post case. So now you guys know that everyone is on social media. They keep on sharing news, they keep on sharing stories. आप लोग reels डालते हैं, YouTube shorts. हम भी social media पे अगर subscribe नहीं किया तो subscribe कर लो, ठीक है. So a post on social media can definitely attract legal acquisitions also if it has done something wrong या वो गलत मैसेज आ रहा है, क्योंकि freedom of speech and expression is somewhere restricted. What exactly happened is, एक person ने, there was a doctor, her name was the Madhuri Kakoti, an FIR was filed against her after she posted a video post Pahalgam terror attack, ठीक है. अब इन्होंने क्या क्वेश्चन रेस किया? इट रेस कॉन्फ्लिक्ट, इट रेस क्वेश्चंस दैट इट इज कॉन्ट्रडिक्टरी एंड कॉन्फ्लिक्टिंग बिटवीन फ्री स्पीच एंड अ पब्लिक ऑर्डर इन अ डिजिटल स्पेस. मतलब उनका कहना ये था, दे वर सेइंग दैट हर पोस्ट इज क्रिएटिंग अ डिजिटल पब्लिक डिसऑर्डर. ऐसा कुछ हुआ नहीं था, नथिंग हैपेंड. शी वाज जस्ट एक्सप्रेसिंग हर कंसर्न टुवर्ड्स द पीपल हु वर स्टक इन कश्मीर, इन पहलगाम. दैट इज व्हाट वाज द कंसर्न शी रेस्ड, बट नथिंग अदर देन दैट. शी डिडंट हैड दैट पॉइंट. So complaint by ABVP student alleged that promotion of disharmony and unrest. So Allahabad High Court came into the picture and they granted interim anticipatory bail to her. Okay. So this was the conflict range. The complainant cited, that is the student cited, that it is potential, it is sufficient, which is going to incite, that is create riots and public disorder in the digital space. This was the question which was raised in that particular case. Now what was the verdict which came? Court have barred arrest. Ki this does not allow an arrest. Has it actually created public order? Now the complainant was saying ki if the public disorder would have happened, then you would have arrested. Court said, first listen, what was the intent of creating that particular post? Is it actually creating a disorder or not? Let's check it. So court barred arrest till final hearing. Case remains under investigation because a proper investigation is needed. भाई आपने पोस्ट डाला, दो ही लोगों ने देखा, उनको फर्क भी नहीं पड़ा, and then it went off for 24 hours के बाद वो स्टोरी भी चली गई. Now what's the case of arresting someone? So proper investigation was needed. It emphasized needs to assess context and content before a legal action. Definitely, what is the context, why you have posted that thing, and what exactly the content was posted. And the last one is interim relief was given, which shows a judicial restraint in criminalizing a speech. A proper restrainment happened in this particular case. Now these have been the legal concepts which came, which talk about an anticipatory bail, because we talk about an interim anticipatory bail was given. So what was that? A legal protection which is being granted before an arrest. So that means a person is about to get arrested, but he applies for an anticipatory bail. So he might be given a legal protection before the actual arrest, allowing a person to avoid custody in anticipation of charges, so that the person, if the charges are frivolous, that the charges does not even exist over here, then in that case that custody needs to be avoided. So you go to the court and ask for the anticipatory bail. Okay. Next, it was also in context, it was mentioned in the verdict about the Bharatiya Nyay Sahita, which replaced our IPC, Indian Penal Code. It includes laws on promoting enmity, national integration and public mischief. So these were the section of BNS which were highlighted, 197 and 196. These are the penal provisions for promoting religious or regional hatred and hurting national unity. So this not exactly happened. This was quoted in that particular judgment which the court brought into over here in the picture. Next was section 69A of the IT Act. What was that? It was also there in the verdict, which stated that it allows the government, so it is a right which has been given to the government to block online content and penalize content which is deemed dangerous to public order and security. So if there is an apprehension that it is going to create a public disorder or it is impacting the security, then the government holds the power to block that content. Okay? So a lot of time the content which have been posted by people is blocked by, because IT rules are there, and all these service providers, the platforms like Instagram, YouTube, Facebook and multiple platforms, they stop these types of contents. And last one is freedom of speech. So it is always under article 19(1)(a), where person has a freedom of speech and expression, but it comes with certain reasonable restrictions in context with public disorder and enmity and everything. Okay? Now we talk about fifth one. The fifth one says free speech has limits on defamation case. So this is in context with a defamation case which was already filed against Rahul Gandhi, one of the member of the Congress party, which was already filed before the elections, where he was doing the rally of Bharat Jodo Yatra. So what exactly happened? So the similar case came into the picture in the month of June also. So the case was based on remarks made during the Bharat Jodo Yatra in December 2022. A retired army officer alleged the remarks defamed the Indian army. So there was a speech which was taken by Rahul Gandhi ji, and then in that speech he must have stated something which became defamatory, and a retired army official has raised this concern that this is objectifying against the reputation of Indian army, which is not correct. So Gandhi had been, a summon had been issued under section 500 of IPC by a Lucknow magistrate, and Allahabad High Court refused to quash a defamation case against Rahul Gandhi. So this is what was the context over here. So the question is, Gandhi have argued that his comments were protected under article 19(1)(a), and the complainant argued, that is the retired army official, he argued that the statement harmed army's reputation and public trust. So the final verdict came that the armed officer deserves protection from the reputational harm, and he has been issued a summon under section 500 of IPC, and the court emphasized that leaders must be cautious in public when they say anything about any political party member, because they are not in a parliament. There is a parliamentary privilege which they may have. That is an exception to the case of defamation. So that is where these provisions come. So what is defamation? It is basically a statement which has been given by one person against another person, which damages that someone's reputation and causing public harm or discredit, but that particular statement which is harming should be published in the public domain also. Then section 482 of CRPC also was given, which gives High Court an interim powers to prevent the abuse of the court process or to secure justice, often used to seek quashing of the criminal cases. So where the High Court come into the picture, where they believe that there is a misuse of the power which is happening in a case or in the entire proceeding, then they will going to take the case into their hands, and even the same power have been given to the Supreme Court also. And what was section 500 of IPC? That deals with the criminal defamation, punishing those who harm someone's reputation through false statements, and article 19(1)(a), it is guaranteeing right to freedom of speech and expression to all the citizens, but subject to certain conditions. So that was the case. So now as we move to the other sixth one, the CLK, that is the preventive detention cannot override bail orders. So that means there is already a bail order which was issued against a particular accused, and he has been preventively detained by another order. Can that particular thing allowed or not? So what exactly happened is, man was already out on a bail, was detained again under the Kerala Anti-Social Activity Prevention Act 2007. That means bail order was already issued. That means a court order was issued, and the moment he was out on bail, there was another order which was under this particular section, where they mention about Kerala Anti-Social Activities Prevention Act 2007 ke under they wanted him to be detained. So the wife have appealed to the Supreme Court after the Kerala High Court have upheld the detention. Supreme Court quashed a preventive detention order in Kerala. That means when the Kerala High Court have issued the preventive detention order, the Supreme Court came into the picture and they quashed it on the application which was done by the wife. So the question was a core conflict: can the state detain someone already who were granted bail? So is it contradiction to the decision which the court has already given and now you are taking it back by another court? So it highlights the misuse of the preventive detention to bypass judicial process. So basically, preventive detention is a concept where we want a person to be detained in the custody because he can go out and he can do some mischief with the evidences or with the witness, or he might flee away because there have been cases and allegations against that particular person. So the final verdict came as the Supreme Court have annulled both detention order and Kerala High Court ruling also. They have ordered immediate release of the detainee, that means who was taken into the custody under the preventive detention, and the preventive detention is an exceptional measure, not a substitute for trial. So it says that it's an exceptional measure, means can only be taken in the cases when you can clearly explain it to the court that if he is out on bail, he is going to create some ruckus, he is going to create some public disorder. Okay? And there was no evidence also that he is endangering public order. So the preventive detention is talking about the custody of a person not for a committed crime but to prevent future unlawful acts must be used sparingly and lawful. So future में होने वाले कुछ अगर lawful misfeasance होंगे, in that case, what is Article 21 that was quoted by the Supreme Court in the judgment, which guarantees protection of person's life and personal liberty. Any curtailment must follow the procedure established by law. That means if there is a procedure which has been followed properly, then in that case this could have been restricted but not in any generic circumstances. Article 22 sub-article 3b says it permits preventive detention can be done but exempts detainee from certain rights such as being produced before a magistrate also. And what could be public order and law and order, because the Supreme Court have even stated that if it is endangering public order, is it against law and order? So let's understand. Public order refers to the broader social peace, while law and order refers to isolated or a routine crime. Detention laws applies only when public order is public order has been threatened. That means law and order पे impact नहीं हो रहा है. Law and order is a very smaller part. Public order is which is impacting the society peace at a larger aspect. So that was the case. Next we talk about an actual transfer not needed for extortion threat. That means this is in case with the extortion. So a person was given a threatened call by one of the party and it was given to the businessman. I think it's being mentioned that a betel nut businessman have been given a call, a threatening call, and was asked to pay some money, else he will be killed or his family will going to be disturbed or anything going to be there. So he was threatened at a gunpoint and 5 lakh per month needs to be given by him or shut his particular business. So High Court have quashed the case claiming no property was delivered, thus no extortion. That means he went to the court and brought a case of extortion, and then High Court stated that it is not an extortion case because there was no real property which was delivered. It was only a threat which you have received over the call. It will not amount. So now the Supreme Court came into the picture and say there is a misapplication of section 383 and 387 was wrongly misinterpreted, and we'll understand what is 383 and 387 because it is in context with the extortion only under IPC, which requires a property transfer instead of section 387, and 387 covers threats or death of grievous hurt even if no transfer happens. So they have applied 383, that was extortion, and they have not given due regard to 387 of IPC. So let's say what was the final verdict. So Supreme Court have reinstated criminal complaint under 387 because 387 talks about that even though you get a threat and there is no actual transfer of property, then also it will amount to extortion. That was the explanation, and that's why he reinstated it and guide court to apply the correct provision. Do not conflate or confuse between section 383 and 387. Now what exactly it says? 383 extortion bolta hai. So let's understand extortion properly. It occurs when a person with intention is putting another person. But if I am putting you under a fear of injury, that I'm going to kill you, hurt you, and actually obtains the property or money as a result, and obtaining the money. So it actually talks about a threat of injury and taking the property. But there is 387 also, which says putting in fear of death or grievous hurt for extortion. So it's a grave offense which a person would be under the criminal offense, where even though no property has been actually been delivered. And the court even stated this, one of the landmark judgment which happened in 2020, where it stated that the confirming that the threats made with extortionate intent, it is not a necessity that the actual property needs to be delivered. So that is what was the verdict came. Next it says misuse of section 498 of IPC. Now this is in context with the cruelty section, where the wife has filed a case against the husband. So it's okay because there was a case of cruelty which happened with the wife and she has put up the grounds. But she not only brought husband under this purview of the case, she even asked all the in-laws, all the family members, even the extended family members, that the entire family is going to be held liable because they have done cruelty. Now this was something which raised concern, so let's understand. So FIR was filed. She alleged that there was a cruelty and dowry harassment under sections 498, 323, 505 and these sections of the Dowry Prohibition Act happened. So what was the actual question was whether a particular vague or a non-specific allegation against extended in-laws can justify criminal proceedings. So imagine a situation that wife has brought a case against husband who stays with his mother and father. Okay, so that means there are 4 in a family, and the other family people stays outside that particular state, maybe in some another state. So she brought case against all the family members, that everyone is involved under cruelty and dowry, and that's why she has raised concern. So this was a particular question which was found out, that even though if the husband has actually done cruelty and a dowry demand, so he might be held liable but not the extended family, so they restricted it. So criminal proceedings to continue against the husband, a prima facie case exists because there are evidences and she has even raised concerns before also. And FIR against parents, sisters and relatives were quashed because they were nowhere involved, because the couple was not staying together, they were staying separately. So if something has happened between them, how can parents be held liable until unless there is an evidentiary proof that the parents were supporting and provoking the husband, and that's why he was demanding money and did cruelty. So 498 talks about punishes cruelty by husband or relatives towards a wife. So it is punishing relatives, but the wife has taken a wrong interpretation, and not even a wrong interpretation, she has even misused this particular law in order to bring a case and want to justify it before everyone. And section 4 of Dowry Prohibition Act was also there, which penalizes anyone who demands dowry directly or indirectly. But in this case there was no evidentiary proof which the wife has. Okay. Now 9th case talk about Delhi High Court on pedestrian negligence and a zebra crossing. So this was the case which was not a recent case but happened earlier, where there was a road accident which happened in which the claimant, which Mr. Manoj Saw, suffered serious injuries while crossing the road from the extreme left side. Now everyone knows that there is a zebra crossing. Okay? Now on zebra crossing, the pedestrians are allowed to walk while the signal is red. That is, everyone knows. But if someone is crossing the pedestrian line at the extreme corner, will that person be held negligent, and because of him the accident happened, should be the real case? That is what was brought over here. But what exactly happened? There was a concept of contributory negligence which was highlighted over here. That means that even though the accident happened, the pedestrian was equally responsible, and so is the reason the Motor Accident Claim Tribunal finds that held that the injured pedestrian is 25% responsible. That means accident hua, the one who has done the accident is not 100% responsible, he is 75% responsible, 25% zimmedari that pedestrian holds. This was done by the tribunal who deals with the motor car accident incidents, okay, motor accident cases. Now that is what was the concern which was raised, that even though if he was walking on the corner side of the pedestrian, the zebra crossing, is that white putty exactly establishes that he is equally liable. So the question was, should compensation be reduced solely based on crossing point So that means if the pedestrian is asking compensation of 10,000, the court stated he will not going to get 10,000, he will going to get 7,500 only. 2,500 रुपए का cut होगा because he was equally involved. So that is what was the case कि will compensation would be reduced just because he was crossing at a particular point he was crossing. So the concern raised and went to the court. So court have reduced the contributory negligence from 25% to 10% and directed the tribunal to recalculate the compensation, including a 25% additional for the loss of the future prospects also, and there was a decision which was already been taken in this particular Sethi case. Okay? So the legal concept talks about a contributory negligence and the motor accident claim tribunal also, and certain sections which talks about the rash driving and also the grievous hurt which is endangering human life. So these are the concepts, you must have already went through these concepts. Let's go to the last one which talks about employment in Article 12, which says if there is a society, that doesn't mean that it's a government job. That means if you are being part of any group, any society which might be funded by the government, does not seems to be equated with the employment in a government job, because if you are designating yourself as that I am an employee of a government job, you might be given a lot of perks. So that was the question. So the petitioner had earlier worked as a craft teacher of TTWRES, which is a Tripura Tribal Welfare Department, an autonomous body, which claimed that this is equivalent to the government service. He was claiming this thing because he wanted some benefits as a government employee. The question is, issue was whether employment in a government funded society based welfare department but an autonomous society qualifies as a government service, or whether the misrepresentation of this fact invalidates appointment to a new post. So this is what was the question, that he is claiming that I am a part of a government, I was doing a government job, and the question stated further that अगर आप झूठ बोल रहे हो, if there is a misrepresentation, will he be barred to get any new post in the near future? So that was the question. So the final verdict came that the Supreme Court has dismissed the appeal, upholding that the petitioner's termination and affirming that employment in a society, even one under Article 12, does not automatically confers the status of a government job. The appointment obtained through false declaration was deemed voidable. That means if you have stated that earlier I worked as an employee of a government job and that's why I can take this, because a lot of jobs has an eligibility that you must have experience before as a government employee or an employee in a government department, and you are saying yes. Why? Because you were working in this Tripura Tribal Welfare Department, an autonomous body. That is why court says no, because when he was not given a job by a new organization with for where जहाँ पे eligibility था कि भाई आप government department से होने चाहिए, उसने बोला हाँ मैं हूँ, but when he was appointed he was not given that particular job because it came to be wrong and a misrepresentation of fact. So that's why Supreme Court came कि complainant ने अगर ये raise किया है, he will not be allowed. So the legal concept over here is Article 12, which mentions about what does the term state says, and it includes multiple bodies including government, parliament and so, and any other authority which the parliament thinks fit can be becoming part or to be controlled by the government. And also the government servant has been defined under the rule 2H of these rules, which says a person who is holding a civil post under the union or the state, mere association with a government funded body is not enough, and he was associated with the TTWREIS. So here we are ending up the today's session. I hope everyone must have note down all the important points which I mentioned over here. You must have understood it. Still, if you believe that there is anything which has not been done or still undone, please drop into the comments and let us know. Till then, Siddhant sir signing off, and don't forget to watch all our upcoming videos on the YouTube channel of Get Set Law by IMS. Thank you so much.